thank you so much for joining us for our webinar today. I am so excited to be joined by Sharon and for her to share in her legal knowledge with us, specifically around the master service agreements. So, thank you so much, Sharon, for joining me today.
I'm super excited to be here with you, Hannah. Thanks for having me. We're going to have a great conversation about master service agreements.
Awesome. Yeah. All right. Okay, perfect. Well, then we'll go ahead and get started. So we're going to be giving y'all tips on everything that you need to know about master service agreements for creative agencies. Also know that there is a Q&A and a chat as well. So if you want to put your questions there, we will be sure to get those answered by Sharon while we are on the webinar today. And you can always email her afterwards if you think of something after the fact. And so just to introduce myself, my name is Hannah Hood. I am a virtual CFO here at Summit Virtual CFO by Anders. I am also the podcast co-host of the Young CPA Success Show. And I realize that y'all may not be my target audience for that, but we have some really cool and fun conversations over there that I'm excited about. And we also have a suite of podcasts, even one specifically for creative agencies that I'd love for y'all to tune into. Um, there we go. I introduced myself. So there you go. Get to see my face again. So there we go. Awesome. I did want to give y'all a little bit of background about us as a firm. We started as a traditional CPA firm back in 2002 by Jody Grundon and Adam Hale, who you see in the picture respectively. They were super traditional doing tax and audit. And then in 2004, they started offering CFO and back office accounting services, really before the industry started making a movement towards that. And then in 2013, again, pre-pandemic, we became a fully distributed firm. And then in 2022, we joined Anders CPAs and Advisors, which is a regional accounting firm out of St. Louis. We merged with them and grew our manpower and our efforts. And that has been a really fun journey to be on. And so that now brings us to where we have transitioned to being Summit Virtual CFO by Anders. So that's a little background on who we are as a firm. And then we have Sharon with us. Thank you again. And thank you to our audience for being really patient and giving us a lot of grace and figuring this out. Sharon, I would love for you to introduce yourself to our audience.
Thanks, Hannah. I founded Toerek Law about 10 years ago. We do business in the agency community as legal and creative, and we focus on helping independent marketing, creative services, digital media, agencies of just about any discipline who are independent, small to mid in size across the United States. We help them in three buckets, basically intellectual property, protection and monetization, contract development and negotiation, and marketing regulation compliance. So those touch on the high points of most agencies' legal issues and questions on a day-to-day basis. And I'm an IP lawyer by training and background, which is sort of how the doorway I went through to get into the creative and marketing world. And then we decided to found this firm to focus just on agencies because they were really underserved in the market. And so our most frequently requested service involves contract development and negotiation, and that's what we're going to talk about today with respect to your agency and its client contracts.
You know, whenever I start talking numbers with some of my clients and to people in general, like I can see like their eyes kind of go like, I did not like that is not my thing. I think I just experienced that with legal. So I am so excited that you are an expert in that because this is so not anything that I feel like I am. And I feel like it is so necessary to the process, especially for our business owners, to have their arms around their master service agreements, negotiations, all the pieces that play into that. So I'm excited to hear what you've got for us today.
And what our mantra really is that we want agencies to see legal as a profit center for them. And one of the best illustrations of that is having well-developed contract templates, well-developed contract negotiation skills, because it results in more money in the pockets of the agency at the end of the day. And so the master service agreement, that's just one potential term for what we mean when we say client agreements in general for agencies, whether you call yours a professional service agreement or a client services agreement, it's all the same to me from a legal perspective. And I like to give folks sort of a roadmap at the beginning of a session about where we're headed. And I'm going to move pretty quickly through the materials because today's session really was designed to give us as much time for Q&A as possible at the end. So I'm going to be taking kind of a fast clip through these. If you do have comments or questions or anything's unclear, just let us know in the comments. Let's back up one, Hannah.
Okay.
Yeah, we'll go through the process today of engaging a client via a contract, typical agreement terms, and some pointers about those, and then the negotiation process itself, and some tips about how to handle negotiations on certain deal points throughout your discussions with potential clients. All right, so the first question we get a lot of times from agencies who are sort of contemplating their process and their systems for engaging or documenting their relationships with clients is, whose contract are we signing? And a lot of agencies who work with enterprise sized clients, government agencies, um, you know, question sometimes why they need to focus on having their own master service agreement when they're going to be signing paper that the client puts forth in front of them. So the first question is, whose MSA form will you use? And I'm here to tell you that it's not always a foregone conclusion, and I'll explain what I mean about that in a second. When in the process do you actually start having negotiations about the contract? It's sooner than you think many times. And who should participate in the process? Who are the people on both sides of the table who you need to have involved so that you can streamline the process as much as possible? All right, let's talk about the contract form itself. It's a legitimate question. Why do we need to be concerned about having our own master service agreement when we work with the types of clientele who give us a hard time about about using our agreements, or who have a well vetted process on their end and expect us to sign their paper? And, to that, I would say it's not always predetermined. We can go to the next slide, Hannah. Sorry for the constant next sliding, everybody, but it's just a function of having Hannah drive while I talk.
That's okay.
It's not always predetermined. You would be surprised at the number of times you can get your contract in front of a client who typically likes to use their paper, either because it's a piece of work that needs to be done quickly and you need to expedite the process fast. And frankly, you're more nimble and limber than their legal department is at the client. It's also possible that if you're working on a project engagement versus a long-term or big dollar engagement with the client, that your marketing counterpart will have enough negotiating authority to just agree to your terms without having to run it up their channels within the organization. And so it's not always predetermined. And there's other good reasons as well to have your own master service agreement.
Do you find that there is a certain amount of knowledge that you would expect, like the internal team to have about these negotiations, about the process, and redlining that whenever they do maybe get that back from the actual client themselves before they would then bring someone like you in or take it another place? Like, is there some expectation that, like, hey, your team in general should know at least up until this point and feel comfortable with where they're at and their background on that?
Yeah, I think that we really advocate for as centralized a process as possible within the agency for contract negotiations. This means that as narrow a set of people and as narrow a set of forms as possible so that everybody is familiar with what's in your contract and why it's there, and they can explain it to a potential client who might have questions about it. So, we'll talk about the necessary parties to have around the table, but we do find that many times clients and agencies during this phase of the relationship end up having very long discussions about deal points that end up not being relevant because the marketing team member who's actually hiring the agency doesn't particularly care about those things, or because the scope of work doesn't touch on some of the areas of liability, for example, that might be in a client agreement. So as I've said, it gets you to the negotiation table quicker in some circumstances. Even if that's not the case, it's definitely sets a more level playing field in your negotiations with a client for them to know that you have pre-considered what your benchmarks are from a legal perspective, what you're expecting the client to agree to, and what they should be expecting you to agree to. It indicates to them that you've take your negotiating position seriously, and you should, because you have more leverage at this point in the conversation than you ever will in the relationship with the client, just about. So you should use it to your advantage. And it's also a great benchmarking tool. Having your own agency master service agreement is an internal checklist of what you're looking for in the client's version of a contract if you decide to end up signing that one instead. So a very well considered set of legal terms and conditions in your own agreement form, and well explained and socialized throughout your agency amongst the people who are going to have authority to sign these agreements or approve of the terms, is a super smart investment and will save you a lot of time and energy later getting your deal papered so that you can get to work and start those retainer and project fee payments coming as quickly as possible. All right, when do the negotiations actually start? And as I said earlier, it can be sooner than you think. If you're an agency that is that regularly participates in RFP responses, or even if you don't believe in participating in RFP processes, if you are an agency that does a lot of pitching, the way you set up your responses to RFPs, the way you describe the work you're going to do in your pitch and proposal, is really the beginning of the negotiation phase, because it can set the table on some of the important business terms you're going to be negotiating later in the agreement. And with larger clients, what we have found is that it's negotiating the SOW, the actual, what we call 3Ds, the deadlines, the dollars, and the deliverables, negotiating that stuff along with the legal terms and conditions many times happens in tandem. And for some really, really big client organizations, if you're participating in their RFP process, they may want to hear from you up front about what you think of their MSA. And it's really hard to know how to negotiate or object to something in an MSA if you haven't thought through your scope of work considerations. So it starts sooner than you think in some cases.
What I'm hearing is that you need to be prepared. Be prepared as early as possible whenever you go to the table with these things, because I think in the digital agency world, we all know that like the billable hour and the concept of the fact that time is money. And so being prepared, I think will go leaps and bounds whenever you're entering into an RFI, RFP process.
Yeah, that's right. Preparation is super important. As And having this pre-considered and documented in your own toolkit is a way to show and establish that you've considered these things carefully and have done your homework and preparation, which puts you on a more level playing field during the negotiations. All right, we can go to the next slide, Hannah. All right, who's involved? Definitely your agency leadership, whether that's you as the principal of the agency or whether it's the head of your account team. Obviously should be involved in all steps of the negotiation. Sometimes your legal counsel, and how does that show up? It can show up either in one of two ways. We have a new opportunity with a client. They want us to sign their master service agreement, and we're not sure which of these provisions are strikeable or irrelevant or too heavy-handed or setting us up for too much liability. At that point, you kind of know you need to bring legal counsel in to review it. If you have your own version of a contract, you present it to the client and they send it back to you with red lines or pushback. That's when you know you probably need to get agency legal counsel involved on your behalf. On the client side, your client procurement rep, if they have a procurement process on the client side, their legal rep. And let me tell you that the procurement rep and the legal rep are not always on the same page on the client side of the table. And it isn't because of anything other than they just have not talked about your deal. You'd be shocked at how many negotiations occur and the internal constituents of your client's organization, they haven't even talked about the contract. Or so this is why I say you got your client marketing counterpart, your true client in the organization, keep them involved at all times because they're the ones who can avoid you having to negotiate deal points that they frankly don't care about, given the kind of work that you're going to do or given their urgency to work with you.
Do you feel like you would expect the marketing counterpoint to know a certain points of non-negotiables in these negotiation processes and just have some really bright lines about the things that they're not willing to concede on?
There are potentially some points which are extremely relevant to your marketing counterpart. One of them is likely to be portfolio and publicity rights. They're probably going to want to control or have oversight of you using samples of work that you've done for them, either in case studies or as portfolio pieces that you want to use for promotional or marketing purposes for the agency. They might also have a strong point of view about even using their name or their logo on your, on your Hall of Fame and in your website. And those become negotiation deal points. They are also going to probably care about exclusivity. If exclusivity is an expectation of the brand, then the marketing counterpart is going to be very invested in negotiating that point with you. And well, we have a couple slides here on exclusivity. I could spend a whole session talking about it and how to approach it, but those are the things that marketing is likely to care about. All right, let's talk about some agreement terms that you need to be thinking about. Billing and collection. Agencies are actually pretty good about thinking through their billing policies, their collection practices, but I want to give you some things that perhaps aren't on your radar every day to be considered in your contracts or in your billing policies. First of all, the simple payment terms are pretty easy to establish. We expect net 30, net 60. If you're working with really large organizations, possibly net 90 terms. That's great. However, when does the payment clock start running? Sometimes does it start running when they get your invoice? Does it start running when they approve your invoice? What's their approval window? It can be up to 30 days, and then you've turned 30-day terms into 60-day terms. What if there are billing disagreements? What's the escalation practice of the client, and how long does that take? That will stretch your terms out. Do you have to bill them within a certain amount of time of completing work? This is a thing, believe it or not, with some clients. And if you haven't done that, are you forfeiting your fees? If so, you've got to keep track of that. Prevailing party language for billing disputes. Who pays fees if if the dispute comes to loggerheads and litigation, does one party have to pay if they're not the prevailing party in the dispute? So these are things to think of beyond. The other thing I would say to you is if you are expecting to collect attorney fees or collection costs of having to proceed against a client who hasn't paid, those things need to be in your contract. They won't be enforceable otherwise, and you will not be made whole for those costs, even if you're right and they do owe you the money. Okay.
I would say from a financial lens, this is where I see the most exposure myself whenever I'm having conversations with my clients and we're trying to collect. We, refer back to that MSA and say, okay, like what does it say? And what I've found, especially for newer clients that come to us, that it is very vague and it is very broad and it is not specific enough about what the terms are. Like you said, like when does the clock start ticking and what the escalation process is. So I am currently in a situation with a client where we are trying to redefine that for us. So that way we can make sure that we have some really good parameters around our expectations here.
Right. I think that's really wise. And I think, looking at your business model every once in a while and your payment milestones, and these should be reflected in your statement of work too, makes a lot of sense and also bifurcating your billing. For those of you who do a lot of third party expense pass-throughs, particularly for media, you should be thinking about bifurcating your billing. And what I mean by that is billing on two tracks. If you're required to bill in arrears for services, fine, but billing in advance for out-of-pocket expenses and or media purchases. That's a way to protect your cash flow and not be out over your skis on money on behalf of a client when you haven't been paid yet.
That's great
Yeah.
advice.
Yeah. All right, insurance coverage and limits. The first thing to consider, and again, this is where having your SOW pre-considered and well thought through is important. What kind of coverage is really appropriate for this kind of relationship and the kind of work you're going to be doing? You should expect to be requested to have general liability insurance coverage. You should expect to be requested to have errors and omissions coverage. To the extent your agency doesn't have it, please get it. It's at least start with $1 million a year. It's much more cost effective than you think it is. But then beyond that, you go into things like employer practices, insurance coverage. Do you really want to take on that obligation, and is it really appropriate given the spend that the client is making with you? You've got to think about that. Car insurance for company cars. Are you going to be driving to client sites? Are you going to be working fully remotely? Is that really necessary? Cyber insurance. Increasingly, you can be expected to prove you have cyber insurance. The practice is becoming increasingly, if not entirely, digital, and cyber events are an increasing concern among clients. So exploring having that as a rider to your general liability or E&O policy is appropriate. What kind of policy limits? We're seeing 2 to 5 million as a typical request. Um, any more than that, and the spend really needs to warrant it. You need to be thinking about how much money the client is spending with you annually. It's been a while since I've seen anything less than 2 million, but you might, I mean, if you're working with mid-sized companies or small businesses, they may not require it at all, or if they do, it might be in smaller limits. So the bottom line here is the type of coverage the client's asking for appropriate for the kind of work and the amount of work being done, and are the policy limits appropriate given the amount of exposure that you might be facing?
Do you feel like this is a negotiation point? Like if for some reason a client
Yeah.
had maybe only $1 million of coverage, but the MSA is requesting that they have 2 million, do you feel like that is something that they could go back to the table and say, no, we're going to bring this down to maybe $1 million?
I absolutely do think that it's a negotiation point. I also think that in addition to having a good CPA firm in your stable, having a good insurance broker who understands your business is important because they can quickly tell you whether or not the fee differential between 1 million and 2 million in coverage is going to be worth your time to argue about. If it's a few $100s a year, you may just, bind the coverage and call it a day and move on to the next thing. So having those people on your speed dial is important to getting through some of this stuff with some expediency.
Actually have a background in insurance, so I'm a virtual CFO. But in another life, I was a licensed insurance agent. And so one thing that
No
I try to
kidding.
do whenever my clients come on is I try to review their insurance policies, and I've found that there's a lot of exposure that just not knowing what the coverages that they need are. They just don't have them. So it's a really good opportunity right now, especially before you're in a process where you're in a negotiation process, to go ahead and review those. Just make sure you at least have everything in line from what the minimal expectation would be. And just make sure that, that is in line. That way, if you get to the negotiation table and there ends up, being more, it doesn't feel like such an exponential hit to what you're currently starting with.
Right. And every once in a while, you will get through the contract negotiation, and an agency will get busy doing the work and every other thing that it has to do, and they will forget to bind the increased coverage. So it's a good idea to take a look at an audit once a year at all your coverages versus what you've committed your coverages will be to the client, so that you are in compliance with your agreement in case something happens. So it's just one of those things for good health of the agency you need to do on a regular basis. All right. This is a topic near and dear to my heart. I'm regretfully going to have to race through it like the rest of these things, but um, you may think your inventory is billable hours. I disagree. I think your inventory is intellectual property. It is the ideation that you develop. It's the concepts. It's the strategies. Um, I agree that it is expressed for many of you in the form of time or some other flat fee type of arrangement or on a retainer arrangement, but it's usually the case that you and your clients are on the same page about who's going to own the work at the end of the day when it's completed. Um, but what isn't then usually the same is the client's contract will say they own the work from the time you create it. It's a work for hire. What you should be agreeing to is it being a work for hire for them once you've been paid. And that's a provision that will frequently be missing from the client's version of an agreement, but which should always be present in your version of the agreement and which you should be pushing for if you're redlining the client contract. That's fine if you're going to provide them with all the rights to all the work at the end of the day, but you need to trigger it to happen until not after you're paid. So that's the first thing I want you to come away with. The second thing I want you to think about is that many of you are creating deliverables that will incorporate some of your pre-existing intellectual property. Some of you have software products, you have content libraries, you have original proprietary research that you've done that will impact or be incorporated in some way or fashion into the deliverable. That stuff is only licensed to the client. You should not be agreeing to its inclusion as a work for hire. You should be carving it out as pre-existing. Sometimes you'll hear it called pre-existing work, background work, whatever the terminology, but what's yours needs to maintain yours because you're going to use it to deliver work to the next client, right? So it's your intellectual property. And then as to third party stuff, stock photography, fonts, software, you need to settle the responsibility in the agreement and for who's going to obtain the licenses for all of that, who's going to maintain compliance with those licenses, and an acknowledgement by the client that they can't own what you don't create. Same goes for AI created deliverables, which we don't have time to get into today, but work created in whole or in part by an artificial intelligence platform from a legal IP perspective is much like some of these other third party works. You don't own it, so you can't convey the rights to it to your client. So just something to be thinking about as the prevalence of AI continues to grow in all of our daily practices.
Yeah, I think we're seeing that more and more. So that is
Yep.
very wise to take into consideration on an ongoing basis because if you're not paying attention to it, it will creep up on you before you know it. And then you're out of compliance or you're in a very sticky legal situation. And that's absolutely what we want to help protect y'all from.
Yeah, and it can show his head after the relationship ends, either in the form of, hey, we'd like you to send us all of our raw files. And then we have this dispute about, well, do you get the final deliverables or do you get all the files and underlying background work? Um, again, it's all a form of the IP. You have to make a policy decision as an agency and carry through that. So a subset of intellectual property rights is your portfolio and publicity display rights. And Hannah and I were talking a little bit about this earlier. This is something that the marketing counterpart at the negotiating table will care about. Um, a lot of times the client default position in their contract will be, um, don't use any of the work you've created for us. Don't use our name for your promotional or publicity purposes. That's really gold to your agency. And so you need to really work as hard as you can to try to get that stricken from the agreement or get as many exceptions made as possible to it. This is what enables you to pitch for that next piece of business, right? Or to go after that next ideal client of yours. So the midpoint is usually, we'll let you, technically, we will give you permission if you ask. You'll have to ask us for it on a case by case basis, though. That's kind of the midpoint. And then your default should be, we retain the right to use publicly disclosed work for publicity purposes, and including your brand. So you can see the spectrum, right? Don't use it at all. We can use it when we want to for promotional purposes. And then the midpoint is, you can use it when you ask us and we give you approval. Not many agencies want to go back to prior clients and ask for approval after the fact. So
Mhm.
make sure if that's where you've settled, make sure you're asking early about using it for promotional purposes. Okay. Exclusivity, again, the other thing that we talked about earlier that brand managers and marketing counterparts care about. The double-edged sword of specialization or niching in your agency, which I'm a huge fan of the approach. We obviously believe in it for our firm, is that you get well known in a particular industry vertical, or you get well known for a specific skill. And clients get a little bit possessive. They want you to not work for their competitors. They want you to not work for other brands in the same product or service categories. Our stock advice is that you should decline these requests as a default. I also am a realist, and I know that many of you are going to be tempted to agree to them either because it's a client you really want to work with, or it's a project you think is really cool, or it's going to stretch your team, might win you an award, whatever it is. So if you're going to do that, and that's the business decision, I totally support it, but I want you to consider a couple of things. You want to narrow it as much as possible. And there some of the ways to narrow it are to specific companies only, to specific product categories only, for a specific amount of time, which should never be longer than the term of the contract itself. Some brands will try to hold you to exclusivity clauses that extend after the term of the agreement. I'd push back on that. And you want to grandparent in any existing clients who might expand into those product categories or who already are in them. You just don't have that work yet for them. So you want to make certain that the relationships you already have would be carved out of any exclusivity you decide to agree to. And then I would just say on this is not a legal point, but if you're going to agree to exclusivity, you need to be thinking about requiring a very generous minimum spend, or you need to be thinking about premium pricing or premium payment terms or all of the above. This is you are agreeing to have your hands tied for a period of time for a certain category or categories of potential business for you. So do it intentionally and make sure you're getting compensated for it.
Additional compensation as a negotiation term is music to this finance girl's ears. So I love that. And I love that that is a consideration for this and should be taken into consideration if you're going to agree to that.
Right. Absolutely. All right, regulatory compliance. Increasingly, brands are going to expect agencies to take this on, and it's your job at the negotiating table to have an agreement form of your own that pushes this responsibility back towards the client, where, in my opinion, it belongs 99 times out of 100. And also to push back on being be responsible for compliance in areas like data privacy and protection. Most of the time, the data you're using to conduct a campaign was provided by the client anyhow. So why should you be indemnifying the client for that? Influencer marketing regulations. If an influencer who you engage on behalf of the client doesn't follow the FTC's rules, or there's some advertising rule that is broken as a result of the campaign beyond your control, you don't want to have to be responsible for that. So you should seek to limit, obviously, your responsibility for regulation compliance as much as possible. Shift it to the client. Limit your liability and your damages if you can't shift the liability completely, which you won't be able to probably shift it completely. So here's how I tier that. Tier 1, limit it to the amount of fees associated with that particular statement of work and the relationship. Tier 2, limit it to the amount of total fees under the contract with that particular client. And then tier 3, limit it to the amount of policy limits and your errors and omissions insurance. So there's 3 levels. Start with baby steps, right? You start with no liability, then you graduate up through the steps as you have to. So each of those are something additional you can offer throughout the negotiations if you're having a hard time getting to agreement point on this. All right. Okay, we can skip past this one. Let's talk about negotiations. Your strategy might depend on who you're talking to. What I want you to take away from this is that you might be talking with legal representation and procurement representation on behalf of the client about the same deal term, and they want completely different things. They're objecting or pushing back for completely different reasons. And it's important to understand procurement is looking for the lowest possible price. Legal is really looking for risk avoidance, liability limitation, intellectual property ownership. So while procurement might seem to be making a legal point in its negotiations, it's really trying to get a concession that will end up in the client spending less money with you. So just keep that in mind. And, as I said before, and I'll probably repeat, you want to make sure you're talking to everybody and including in your marketing counterpart about this so that they can help grease this along on their end of things. I've conducted a number of negotiations where it was completely clear that nobody on the client side was talking to each other. And it wasn't until our agency client and we got all of them on the phone together that they understood what their true negotiating position was. So keeping your marketing client involved is a good strategy and can be a shortcut when you have a long-term negotiation.
Who do you see most commonly being the lead voice of the negotiations?
Depends on the stage of the negotiation. I can tell you that legal is most likely to be able to stop a deal. Procurement usually can't stop a deal because again, they're usually looking at numbers and there's usually a way to finesse the deal to make it palatable to them. Legal, if they don't like a liability clause the way it's written, they'll continue negotiating with you until you come to some sort of compromise or they win. So I would say getting the legal, they're also extremely overwhelmed with work. They're not fast. Marketing and marketing agencies work at 10x speed compared to
Mhm.
other departments within an enterprise size organization. And if your clients are not enterprises, if they're mid-sized companies or small businesses, they've got 9 million other things on their plate. They are not in as much of a hurry as you are usually. They'd like you to start working, but they're not so concerned about getting the contract signed and getting you paid as fast as you need to. So just keep that in mind. Yeah. All right. We've already beat this horse dead, so we keep going. All right. So another tip, the earlier you're asked to redline the client's contract, the more general you ought to be in your approach. Leave yourself some room to wiggle and to maneuver. Strike provisions altogether rather than suggest rewrites. Do react in a way that provokes a conversation rather than just flat out rejecting. This is if you're negotiating off of their paper. Again, I prefer to you to be negotiating off your own contracts, but um, be broad as possible and as non-committal as possible, especially in that first round. I mean, if there's something you just simply will not live with and it's a deal breaker for you, then you strike it and you're done and you stay consistent. But everything else is usually negotiable.
What do you feel like is one of the things that helps increase the time in getting through some of these things? Is it having those non-negotiables already predetermined and like moving through it so that way this process doesn't hang up, when starting the actual work?
It's having your non-negotiables predetermined and having your own agreement is a good way to do that. And it is having your SOW, your work scope, completely thought through by the time you're negotiating the contract. So you can spot immediately whether a term in their agreement isn't even relevant to the work you're going to be doing. If you're doing a branding project for a client, then data privacy liability doesn't need to be a conversation because you're not going to be handling any data. So it's an immediate strikeout. But if you've not thought through your scope of work first, then um, you lose that time savings, right?
Mhm.
Attributable to that. So those are the best strategies.
Awesome.
Yeah. All right. Next slide. Know your benchmarks. Again, your team should be familiar with what is in your standard contract. If you're not sure if they are or not, then spend an hour on a lunch and learn. Have an in-house training session. Go through the agreement and explain to them. And if you can't explain it to them, get your counsel to help you explain to them why are these terms in there? How do they help us? What do they mean in English? So that if the client presses back, we know why they're there and why they help us. So that's a great way to know the benchmarks, along with having their input into what ought to be in the contract that isn't, because these are living documents that you ought to be looking at on an intermittent basis to update them to reflect the current way your agency does business, right? And with clients. All right, I've talked quickly. The QR code goes to some free resources around agency master service agreement negotiations. There's an FAQ guide in there that's got a lot of great questions that other agency owners have asked us, and our answers to those questions, and some other things for you that you might find helpful. And that's how you can get a hold of me. And I am going to take a pause, and I am happy to answer any and all questions. And I hope you came with some good ones.
Yeah, there's actually two already in the chat that I am going to throw your way.
Okay.
Should indemnification and liability clauses be included in the MSA and website design agreement?
In a website design agreement, in addition to disclaiming liability for data privacy compliance, because you may be putting forms on the website to collect data in exchange for some free content or something like that. So that's one area. Another area is disclaiming legal liability for ADA website accessibility compliance. There's a bit of a cottage industry out there of litigants suing parties who have websites who do not meet the WCG standards. I may be missing a letter there. WCG standards for website accessibility. Remember, the ADA doesn't actually have any full-blown regulations around this. They just have guidelines. But a lot of lawyers have interpreted that as a basis for suing companies with websites saying they're not accessible to people who have disabilities. And so disclaiming that in your contract if you do web services is important. Disclaiming responsibility for technical breakdowns or bugs without giving you a reasonable amount of time to fix them. That's important. And some of this stuff is best put in an addendum to your master
Hmm.
service agreement rather than in the body of it itself. So if you do different specific types of work, that's a good reason to have specific addendums associated with those types of projects. But those are the top three I can think of that are website specific. Um, if you host or host manage, which is the most common practice these days, very few agencies host websites anymore. They really are managing the hosting on AWS or some other platform. Um, disclaiming responsibility for the platform's breakdowns or screw ups with respect to interrupting the website. Those are
That's
important.
really good. That's great. Next question is, what are some legal terms that should be included by default for our agency proposals for RFP?
Well, it's going to be difficult to put proposed legal terms in the RFP response, quite frankly. You can, and I don't think it's wise to attach your agreement to the RFP response. I think it's too soon. If you have a particular point of view around your payment terms being extended, or if you have a particular point of view around, gosh, I can't even think of, if if you're going to be handling a lot of data, if you have a particular point of view around expressing upfront that you're not going to be responsible for data privacy compliance, if you know that you're going to want to use AI tools to service the client, you should probably mention that up front and maybe what your policies are around using generative AI. Those are some good examples. Otherwise, I would keep the RFP response to your 3Ds, which is your deadlines, your dollars, your deliverables, over the legal terminology itself. I think there's a time and a place for that, and it's probably after you're in the running, right, to win the business.
Sure. Yeah, that's really great. Another question that I have thought of as you're going through this. So let's say that a client has already signed a master service agreement and now they've listened to our webinar and they're going back through that service agreement and they're like, oh, shoot, there's some things in here that I probably shouldn't have agreed to.
Yeah.
What would be their process, or do they have any standing to go back on that and say that they want to propose changes?
Well, one of the ways you can clean it up is if you do a new statement of work for every new project for the client. You could alter or deviate from the master service agreement terms in that statement of work as long as the client agrees to it and signs off on it and you both acknowledge it as a deviation. The other thing is sort of docket your rollover dates on these contracts, and when their terms are ready to expire, be ready to present your new version of the agreement with the new provisions that you need in it, and be prepared to talk through the changes and what the business case is for those changes. And You know, beyond that, as much as a contract is binding, if you've got convenience termination language in your agreement, the truth is if you've made a really bad deal, you can use the convenience language and get out of the agreement using that and use that as a hinge to negotiate a new agreement. That is a really complicated decision to make, right?
Sure.
Because it's
I mean, there's a
politics involved.
relationship involved in there in that
Yes,
as well. Yeah.
there's politics and money involved. So you have to
Hmm.
really kind of be super unhappy, in my view, with your current terms to pull that trigger, but it's an option.
Well, that's very, very good to know.
Yeah.
Also, I know we've talked a lot about all of the things that you should include here. Is there anything that you would put in the absolutely do not go there, do not include this in your MSA?
I'm becoming less of an absolutist as times goes on, to be honest with you, Hannah, because most of the times the things that a typical agency lawyer would recommend against, the agency understands that and they've made a considered business decision to include them anyhow. But my favorite things to make sure you don't include or agree to is a work for hire provision that forces you to turn work over from the time it's created. I do not like clients to agree to excessively long payment terms that the client will offer to shorten for you or give you a break on if you basically if you want to borrow your own money back from yourself. They'll discount or shorten your period of payment if you charge them less money. I'm
Mm.
not a fan of that approach. I think it's heavy-handed, and the largest of the large companies use this a lot. Either will give you financing, which is akin to a couple of points off of, the fees that we owe you, or you know, we'll pay you our standard terms. If you want faster terms, we'll pay you less, basically. Stay away from that and try to stay away from exclusivity if you can. If it's not important to you, if you're not a niche agency, then and you're going to include it, then make sure it's worth it financially.
That's very good advice. I appreciate you so much taking time to answer these questions. And obviously, if anybody's listening to the replay on this, Sharon's email is on the screen as well, and you can get in contact with her. We also offer free virtual CFO consultations. So if you're listening to this and you're like, yeah, I just really need more guidance and more oversight in these areas, then we would love to talk more with you about that. You can use the QR code to request an appointment with Christy, our strategic growth director. And then we also have a free dynamic forecasting guide for you. You can scan the QR code and download that. That is written by Jody Grundon, our original founder. So that is a really valuable resource for you as well. And then we invite you to keep learning. We have a podcast that Sharon has been on, the Creative Agency Success Show. There is so much good knowledge that is thrown out on this podcast. So that is an incredibly valuable another free resource for y'all to take advantage of. So I invite you um, to listen, take a listen to that. That's the end of our slideshow there. You will, if you're listening to this, you will be emailed the slides within 2 business days, along with a recording of the presentation. So if you're like, man, there's so much good stuff, I didn't get to take all the notes that I wanted to take, you're going to get a recording and the slides. So I appreciate y'all so much taking an hour out of your day to be with myself and Sharon. And of course, if you have any questions, please don't hesitate to reach out to us. Thanks so much for joining us.
Thanks, everybody.